Hey, Elyse, how are you doing?
Hi, Jonathan. How are you?
Okay, I don't know what happened with my the countdown there. Something kind of strange. Anyway, hey everybody, Jonathan here. This is February 11th, 2026. We are at our regular time for our live stream, and my guest today is Elyse Entin. Elyse is a former Social Security staff attorney, and she's going to tell us a little bit more about. Let's start with that. Tell me about your background. I know you're in private practice now, but tell everybody about who you are and kind of what you're doing now.
Okay, so just retired after 25 years in the federal government. I originally was a career law clerk for a federal magistrate judge, and I worked for him for 11 years. When he retired, I became an attorney advisor for the Social Security Administration. And so I have a very unique background because I started off doing all of the Social Security disability appeals in federal court. And then I went to the hearing office for Social Security Administration, and I started writing the decisions that I used to overturn when I worked for the judge. And so I just have a very unique perspective.
Explain that again. So you're working for the federal court, the district court, or the magistrate judge, and then you went to work for Social Security, and you said you were writing the decisions that you used to overturn. Can you break that down a little bit for me? What is that?
Okay, so if I can explain what happens. So when you file an application for Social Security disability benefits, you file the application with the state agency, the DDS, which is the Disability Determination Services. If you're successful, then you get Social Security disability benefits. Usually, not everyone's successful at that level. So then you file for reconsideration. If you're denied at that level, you file an appeal for a hearing before an administrative law judge. And that would be at with Social Security. And that's where I had worked as an attorney advisor. But if I'm just going to go forward, if the administrative law judge who hears the case denies your application, then you appeal before the appeals council. And if the appeals council denies the case, then you can bring an appeal before a federal magistrate judge or a federal district judge in federal court. And if they rule in your favor, then they remand the case back to the Social Security Administration, back to the appeals council, who remands it back to an administrative law judge to have the hearing again.
So you were working at one point for the federal judge, and then you went to work for the Social Security Administration. So you would write the decisions or draft, maybe a better way to put it is you're drafting decisions for the judge, and some of those decisions might get appealed back to your old office. Is that kind of what I'm hearing?
Well, I did the opposite. So I started off doing the federal court appeals.
Okay.
And then when my judge retired, I went
back to Social Security. Now, one question I've always had about the federal court, which we're not going to spend a lot of time on that. I just wanted to, because I wanted to know, are the appeals to federal court, let's say you go to the appeals council and you lose, does the federal court have to take every case, or is it sort of they take the ones they want to take and just don't even consider ones that are not viable?
If you file,
they're going to look at it.
In federal court, you pay the fee. It will be assigned to a magistrate judge and a district judge.
So there's no certiorari or anything like that where, like, I know people don't necessarily always realize this, but if you file a case and you end up in, let's say, the 11th Circuit or 2nd Circuit or whatever, they don't have to consider that case. They can just say, we're not going to consider the case at all. We're just going to send it back or just refuse to hear it. Supreme Court doesn't hear every case that's brought there. They can deny what they call certiorari, I think is how it's pronounced. Shows you what I remember from law school. But they don't have to consider. But what you're saying is in district court, you lose the appeals council, you will get a decision from district court. They may dismiss it in a paragraph or two, but you get a chance to get heard. So
a lot of times the U.S. Attorney's Office will work. If you have an attorney representing you, a lot of times it's remanded. They come up with some sort of settlements and they remand it back to the back to an administrative law judge.
Okay.
If not, then you're assigned
Right.
to a district judge, and then the district judge will decide whether he or she wants to hear it or they want a magistrate judge to hear it.
Got
And I
it.
will tell you that if you're in a federal appeals court and a district judge, a lot of times, they focus more on the criminal cases and more high profile cases. So if you want a faster decision, I recommend that you agree to a hearing before a magistrate judge
Got it.
because you'll have a faster hearing.
Faster.
It's 636C. That's what it's called, a hearing before a magistrate judge, where you consent, and it'll speed things up.
Okay. Well, obviously, our goal is to not go there. We want to win at the before the administrative law judge, and let's kind of talk about that a little bit. We're going to get some questions in a second, but tell me about your experience working for judges. So basically, I take my client to a hearing in front of a judge. The judge listens theoretically very carefully, although I suspect that many judges have kind of decided already what they're going to do before they walk in the door that morning. But they hear the case. What do they do? What do they give you? You're not actually at the hearing. You're in a different office someplace, toiling away in anonymity, someplace at some cubicle, I guess, right? But they give you. Do they put like a big check mark on it? Do they give you notes? What is the typical scenario for a judge to give it to a decision writer?
So a case will be assigned to a decision writer through the management office, and it's supposed to be first in, first out. So you'll get a case assigned to you, and there'll be instructions. Each judge is supposed to make all the findings, and then send it to the decision writer, which is most usually an attorney advisor, although there are a few paralegals who do it as well. And once it's assigned to us, all the findings are supposed to be there. Unfortunately, most judges do not make all of the findings. And so it's up to the decision writer to look at the evidence and, look at the hearing transcript to see what findings, need to be made. And so, usually the judges will decide, okay, these are the severe impairments. This is the residual functional capacity finding that we want. It's going to be a favorable case. And, that's it. Decided.
Okay. So
Right.
basically, they give you, some of them give you more guidance, but some of them just say, approve the case, you figure out why.
Oh, it used to be, in the past,
Mhm.
the standard was there were some judges who just did a thumbs up or thumbs down. And, and a lot of them have retired.
Yeah.
And then they started saying, you know what, we have to give the decision writers more findings. And that is something that the union has fought for. They said we really need findings because, the decision writers are held to metrics. So I actually have an example here. So if you have a fully favorable case, in the past, it used to be 4 hours to write a fully favorable case and 8 hours for an unfavorable case. Well, they changed the standard. So now they have what's called the DWPI metrics. And so for a fully favorable step 3 finding, you would have 3 hours and 41 minutes. And I should say it's 3.41 time hours, but it's really not 3 hours and 41 minutes. It's less than that. For a fully favorable step 5, you have 4.29.
And just so everybody understands, step 3 is if you meet a listing, right? Or is that kind of what it would be? And then step 5 would be a full analysis. So basically what you're saying is they give you 3.5 hours approximately, maybe a little bit more, to write these decisions if it's favorable. So it's a template, but you got to boom, 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 get these things processed out. And that's how your performance is graded based on how quick you can get them out. And the unfavorables, 8 hours, I think you said.
Well, it's no longer 8 hours. So it's 10.29.
Okay, so you get a little bit more time.
But also the problem is the medical records. The records are a lot bigger than they used to
Right.
be.
Right.
And
Are they
so
using AI at all to analyze the medical records?
I was in the pilot program for Imogen, and which is the internal AI program,
Mm-hmm.
and it was not very good at that point in time. And from what I've heard, it's still not very good.
Okay.
And they really have not given many trainings on it yet to the decision writers. And they're planning to use it soon, but I don't really know if they're going to use it or not.
Okay.
I mean, when I did it, there was just so many problems with it.
Got it. Got it. Okay, let's jump into some of the questions. We'll come back to talking about procedures and things like that. And we'll just go through some of these questions, and I'll answer some, and you can answer some, and we'll just kind of get some perspective. And you're in private practice now, so you're sort of seeing things from the same perspective as me, representing claimants who are trying to get approved for disability benefits. Okay. Jay Arnold says, it's been a year since you applied for SSDI, now getting letters every week asking for phone calls to answer questions. Is this normal? This sounds odd to me. I don't normally hear about people getting phone calls. I assume you're not represented. They will sometimes call you to ask, about new doctors you may have seen or to confirm a medical condition, but that's onesie twosies. These are not typically, multiple calls, and they're not interviewing you on a regular basis. Have you ever heard of this? Does this make any sense to you?
We did it during COVID.
Yeah.
So the attorney, the decision writers, attorney advisors and paralegals would call up the claimants, and mainly it was all pro se claimants at that point in time,
Right.
people who were not represented by counsel, and we would ask questions, and we would try to help them along, get the doctor's information, and and just try to speed up the case. But
This sounds like
after
it's at the
COVID,
administrative
we
stage.
haven't been
Yeah.
doing that. No.
Yeah. I mean, again, it may be legit. I don't know. What I would definitely say to do is, if somebody calls you, ask for their name and their ID number or whatever, and then, look up the office, go to ssa.gov/locator, look up the office where they're supposed to be from, and call back that office and try to see if that person's there. Again, I can't imagine that, identity thieves would be preying on people filing for Social Security disability, but in this world, you never know. And so I think it would be worth at least double checking, because that just seems a little bit odd. I mean, I've done this for 30 something years, and it's pretty rare that I get calls from Social Security asking, can they talk to my clients directly? It does happen sometimes, but it's usually one question, two questions. It's not this sort of ongoing dialogue. That just seems kind of odd to me. Just my take on it.
No, I agree with you on that.
All right. Kevin Johnson says, what does a fully favorable decision mean when you win SSI and SSDI together? That's called a concurrent claim. And basically it means that you are found disabled. The definition of disability, Kevin, is the same for SSDI and SSI. The difference is SSDI is based on your earnings record. SSI is kind of a low income, low asset status program, that you don't necessarily have to have any earnings credits. And really the only time, I'd say 99% of the time, SSI will be involved at all would be if you have a 5-month waiting period. If your SSDI case is such where there's a 5-month waiting period that applies, you can get SSI for those 5 months, or it could be 6 months because it's a partial months don't count in the 5-month waiting period. But generally the SSDI will, after the 5-month waiting period, will offset your SSI. There won't be any more SSI. So you don't, but if you're asking, can you double dip? The answer is no, you don't double dip. You don't get both. You get SSI as long as there's no SSDI. And then once SSDI kicks in, that's when the SSI goes away. So I don't know if that helps you, but it's basically the same definition of disability. One program is based on earnings. One program is based on assets and household income. And again, SSDI is typically more than SSI. Every once in a while, and it's happened 2 or 3 times in 30 years, you have a person whose SSDI amount is less than their SSI amount, and they can get both. But that's pretty rare. So you don't really see that very much. Is that your take on this as well?
Yep.
Yep. Okay. All right. Karen says hello from California. Hello, Karen. BDQ. Hello, BDQ. Cynthia, one of my clients, Cynthia with an I. She's the only Cynthia I've known with an I, so with spelling it that way, but how are you doing? Pamela Holmes. Hello, everyone. Hello, Pamela. Low gamma trader. I don't know what that is. You're testing low gamma, I'm guessing. Okay. T Pitts. Demetrius. Okay. Thank you, Demetrius. I appreciate that. Yes, we won your case. I want to thank you again. Now, did you ever get, I think if you're not if I remember correctly, did you ever get paid? That's the real question, because I know there was some issues with that, well, I'm not going to go into what it was, but there was a hold up on your payment. Did you ever get paid? I hope you did. I don't think I ever got paid on your case. I got to check into that, but good to see you. And thank you very much for the referrals. Appreciate it. Actually, at least there was one that was, I think, Stephanie. I don't see it on my, do you still see that? Somebody had a question. The first one, there was a Stephanie who had a question.
Oh, yes, it's up here.
I don't see it.
Stephanie wrote, "Hello, Jonathan. I just wanted you to know that I was finally approved for my disability, but they moved my onset date to the day before my birthday, which was 1/27. It was 11/2023 on my claim. While I'm happy it's done, but I feel cheated."
Yep. Okay. This is actually a good question. I'm glad you asked it, because I'm dealing with this a lot, and I'm sure you'll be dealing with it as your caseload increases, Elyse. What happened here was that Social Security approved her case, but they changed the onset date. You can appeal that. And I do that analysis, and what you got to look at is how much money are you being shorted? If it's $4,000 or $5,000, probably not worth the risk of appealing. I had one the other day, $100,000. The difference between the original onset date and the changed, and there was no logic at all. I mean, what the logic was, my client was going to be 55 in, I think, April or May, and they found him disabled as of November. There's a rule that says if you're within like 5 or 6 months of your next, threshold birthday, either 50 or 55, they can consider it to be that birthday. So they kind of, move you up to the next birthday. But there was no logical reason for it medically. And again, it was $100,000 differential. And so I called them up and I said, look, the risk, in my opinion, is pretty minor. You've got a lot of stuff going on. Worst comes to worst, they find you disabled at 55. Excuse me, you're no worse off. But if you can be found disabled at 51 under the grids that you're limited to sedentary work, put $100,000 in your pocket. And he agreed. And so we're appealing it. So you can definitely appeal it. You got to appeal within 60 days. They will pay you, which is good. The problem is if you end up losing, and that's the risk, you end up losing, you'll owe them money back. So there's a risk of appealing a partially favorable, let's call it, decision. You draw a really bad judge and, you were approved. That's not binding on the judge. But usually if they approved you administratively, it sort of says to me that you've got a pretty strong case. But I would look at it, and it gets a little complicated because you got to figure out the 5-month waiting period and the date of application, all that stuff. Pardon me. But you can figure out how much money you've been shorted, and you can make a decision within 60 days to appeal. So, but you just got to be careful about that. But that is something that I'd say of the cases that are approved with significant, meaning $20,000 or more, most people say, let's go ahead and appeal it. And I haven't yet to have one get denied. So it doesn't mean one couldn't, but that's been my experience. Would you agree as far as something like that's concerned?
Yes. Well, a lot of times judges will say, we'll find them disabled as of their 50th birthday, and they'll ask their assistant, can you call up and see if they'll accept that, otherwise do a partially favorable. And so they'll deny it before the 50th birthday.
Yeah. I guess you probably would see that more people that are in their late 40s about to turn 50 as opposed to someone who's, in their 54, 50. Although again, if they're 54, easy for a judge to say, we're going to limit you to light RFC, light functional capacity, and grid you out under the light grids. So that does happen too. Obviously, if you're over 55, it's less of an issue. But I think that there's a lot of folks in their late 40s who are going to face this problem where they apply and they get approved as of their 50th, or they're 54 and they apply and they get approved as of their 55th. So I would tell you, if you're 48 or 49, you're 53 or 54, and you're thinking about applying for benefits, apply if you need to apply. But, in some ways it makes, if you can possibly keep working until such time as you pass that threshold, or you get a little closer to it, it may, put more money in your pocket, as opposed to hoping a judge is going to find you disabled at, 44 and 1 month. It's really easier for them just, especially if there's a grid rule involved, than to move you up to that 50th birthday. And it really is. People get angry about it, because I think it's kind of a lazy way out. Am I sort of seeing that kind of correctly? Yeah, that's kind of what I think too. Easy for the judges, but that doesn't help you if you haven't been working, and that extra $15,000 or $20,000 makes a big difference. Christina is one of my regulars from California. Good to see her there. Okay, low gamma was the testing. Warm greetings. Okay, Elyse, I'll let you take this one. Is it possible for the ALJ to approve a claim before a hearing? I'm advanced age with grid rule 202. Probably you mean, I guess, 06.
On the record decision?
Yeah.
Yes. So yes, you can do an on the record decision. Sometimes a judge or a decision writer will say, you know what, you really don't need a hearing.
Yep.
If the facts are so strong in this case, why don't you do an on the record decision?
Yeah.
And so yes, that does happen.
And by it would be 202.06. There is no 202.16, so it's 06. Basically, a person limited to a light functional capacity, light being standing and walking up to 6 hours a day, lifting 20 pounds on occasion, 10 pounds frequently, occasionally being about 3 hours in a day. So it's a pretty physical type of job. The real question in these grid rule cases is transferability of skills. And that's a decision that a judge, will have to make. The argument that I make would be that are the skills unique to your particular industry? If you've done something in one industry, you've been a copier repair person and you've done that for the last 15 years, you probably don't have any transferable skills out of that. And there's probably not a lot of sit-down jobs that a copy repair person could do. So one, it could be it's unique to your particular industry that you've worked in. The second would be if you've got a lot of what are called non-exertional impairments, pain, medication side effects, depression, maybe some bathroom issues, things like that, that you could argue that your non-transferable or your non-exertional impairments would erode or reduce any transferability of skills, so that in fact you're really almost like an unskilled work background, and that's how you get past the transferability skills. Also, at age 55, there is a regulation called the POMS, POMS, which stands for Program Operations Manual. I think that's what it stands for. That basically says that if you're over 55 and you're limited to sedentary, there is a heightened standard for transferability of skills. Has to be what they call minimum vocational adjustment, which makes it even harder for Social Security to prove that you could transfer in. So yeah, if you're advanced age, you're over 55, you otherwise meet 202.06, you could certainly ask the judge to decide your case on the record. I think when I write briefs, and I'm sort of struggling with exactly how to phrase this, and Elyse and I had talked about this, do you simply say, here's my pre-hearing brief, or do you actually ask for the on-the-record decision? Let me ask you your take on that. Do judges get offended if somebody asks for an on-the-record when it's a little more marginal as to whether it really could be on the record, or they just sort of see it as you're being a zealous advocate?
I think you really have to, I think, it really should be clear that it should be an on-the-record decision, rather than, I definitely would not recommend making it in every single case.
Okay.
But if it's that was kind of my thought.
Yeah.
But if it's something that's pretty clear or close to it, I would definitely do.
Yeah, I think that, judges, and again, as attorneys, you see that, and it's less so now because we're all taking cases all over the place because it's, telephone or video. But judges, here's another question: do they kind of know the reputation of the lawyers that appear before them? Do they have any? Do they see a case coming up? Oh, this is lawyer X. You know, he's lazy or he's sloppy. This one is always prepared. Is that part of the calculation?
Behind the scenes,
Yeah.
in both federal court and here, yes, attorneys have reputations. So if you have an attorney who, especially when I was in federal court, we'd see a lot of the same attorneys back and forth, and I would read the briefs. And if I found something that was questionable, like the law, they cite to case law, and the case did not say what the proposition that they're putting out there,
Mhm.
I'm going to question the brief. I'm going to question every single thing that they write here. And then, when it came down to attorney's fees, I would recommend less than they asked for.
Because they were a little bit sloppy. And by the way, this is something that, we've talked in our live stream here about AI as a tool, and I'm using it a good bit in a very specific way. And I know, and at least you and I have talked about how to incorporate AI in various different types of AI programs and all this. My point here is that if you're not represented and you're going to Chat GPT or you're going to Perplexity or Claude or one of these things, you have to be very, very careful because it can make stuff up. A lot of AI tools, for lack of better terms, have a desire to please, and they want you to be happy. As crazy as that may sound, and they will make something up. I mean, I use a closed system, which means it only considers what I give it. But there's information that it has in its database, I guess, whatever it would be, that doesn't. It's not specific information, but knowledge about Social Security that maybe it's picked up from other things. I was looking at one today, and it's talking about the grid rules as of the date of the hearing. Well, that's not correct. And that was something I know you and I talked about the other day. It's the date of the onset is when the grid rules would apply. It's not the date of the hearing. Well, the AI tool thought it was the date of the hearing. And so, if you put that in there, you might be shortchanging yourself, but it also would demonstrate to the judge that either A, you didn't know what you're doing, or you used an AI tool. So you got to be very careful about using AI. It's very powerful, it can do a lot of good things, but you got to check it. And like you said, if it references a citation or a ruling, I remember when I did several months ago, it talked about the treating source rule as being why a judge should consider this evidence. Well, that decision, the treating source rule is gone, been gone for years, but AI didn't know that. So you just got to be very, very careful if you're doing that. All right, Zippy 61. What can we do about the trust fund running out? Is everybody going to get a cut? What is your take? What do you think? The trust fund, what we're talking about here is when we pay our Social Security taxes, it goes into a trust fund. It's a big IOU, but theoretically it goes into a fund that will be used to pay Social Security. And the problem is when Social Security was first created, people were living till they were retiring at 65 and they were dying at 66 or 67. So there was more money, and it was the baby boomer generation. There's more money going in than going out. Now we have a declining birth rate. The baby boomers are all retiring, and there's fewer workers to make up the difference. And workers, younger workers, aren't making as much money. Well, meanwhile, you have people in retirement and disability who are draining the system. And so, according to the statistics you see, in 7 or 8 years, that Social Security trust fund, the disability trust fund, is going to run out of money, maybe the retirement one as well. My guess would be that Congress is going to step in at the very last minute and do something. What do you think? Would you agree?
I agree with you on that.
Yeah. I don't think they can afford, the AARP is too powerful of a lobby. But I do think that, we've seen some efforts certainly by the current administration and previous administrations to make it more difficult to win disability. And so it wouldn't surprise me to see that. It hasn't happened yet. Now I know Walter Knott, who does another live stream, he's very active and does really good work. He is of the opinion that there was an effort earlier this year to change the system so that age would not be as much of a factor, i.e., modify or eliminate the grid rules. He thinks that's likely to happen. What's your take? Do you think that they would do something like that?
That was a rumor that I
Yeah.
had heard when I was at the agency. I really don't know what they're going to do because they make changes and it has to go through Congress and
Yep.
they have to present it to attorneys and public. So I don't want to venture a guess, but it's a possibility.
There's some talk about that. When you were at the agency, and I know that it's a very hierarchical agency, different levels of administrators and so forth. How much interaction did you have with the commissioner, the commissioner's office, things like that? Were these people accessible, or were they sort of in an ivory tower someplace in Washington you never heard from them?
They were in ivory tower.
Yeah.
At one point, this was when I first started, one of the first couple of years, the assistant commissioner came to talk to all the different hearing offices. And she came in, this was Terry Gruber at the time, and she came in and just asked questions. And I raised my hand and I had a question about the transcripts. And I said, they're really not very good. We're not supposed
You're talking about the hearing transcripts.
The hearing transcripts, I'm sorry.
Okay.
I said, the hearing transcripts are not very good. The attorney advisors are not supposed to listen to hearings. We're supposed to rely on the transcripts because, we have a very limited amount of time to write decisions and the transcript is supposed to be clear. And I quoted quoted part of the hearing transcript, which said, walk around the block, cooking husband. And it was, I think the person had meant to say, what do you do in your spare time? I walk around the block. Who does the cooking? The husband.
Yeah.
But this was what
the transcript
hearing office court reporter wrote. And so here I am supposed to rely on this, that she's walking around the block cooking her husband. It was just ridiculous. So, that was something that they were going to look into. And eventually, actually, fairly recently in the last couple of years, they switched over to what's called the heart transcripts, where they're actually recording it. And it's kind of like AI generated.
Right.
The transcripts are much better now. Okay. And you can rely on them.
Didn't Terry Gruber get herself in some trouble? Didn't she get fired?
I think she may have passed away, but yeah, there was
some issue about, I remember something like that it wasn't pleasant, but rest in peace, Terry Gruber. So all right, Maureen Shannon. Good evening, Maureen. How are you doing? P. Brown, can you explain what's happening when the case is moved to stage 4? All right, this is a question I get all the time, and you may not know the answer because I don't really know the answer. People log into their My Social Security statement or My Social Security account, and they say, your case is now at step 4. Does that mean anything? Or is that just sort of a something that they say to placate the angry masses? I just don't think it means anything, because step 4 for my world is, the 5-step sequential evaluation process, but this is apparently step 4 in terms of case processing. Does that have any meaning to your knowledge?
I have no idea. I've never heard that.
Never heard of it. Okay. Yeah. Somebody said one time that it meant that the case was going from, the adjudicator had completed their review and they're sending it to the medical specialist. And then after the medical specialist, it comes back, and that they change because it'll say, your case is 73% done. And then, 2 weeks later, it's 74%. Then it goes to 93%. I just think that's just a bunch of garbage. I'll be polite. That just is a way to keep people from, contacting their Congress people. So that's my take. But I don't think that step 4 means a whole hill of beans, because it doesn't really obligate Social Security to complete your case or complete the review in any specific time frame. It just means that it's moving along. But it doesn't mean it's moving along quickly, or when it's going to be to the end. It is what it is. All right, Sodella Rosa. Hello, Sodella Rosa. How are you doing? Christina says, please share it. Yes, please do share it. In fact, we were talking about this because Elyse was saying her husband was having trouble getting the link. Let me actually stop. I'm going to put the link in the notes here so that anybody who wants to share it can share it. It's on the YouTube channel. It's on the Facebook page. It's on Instagram. We're all over the place. But if you don't have the link, there you go. All right. Chan Tet. Hello, Chan. Good to see you again. My pleasure. We are happy to share what we know because you know what? This is somewhat of a black box. I mean, Social Security doesn't make it real easy to understand it. You know, if you think about it, the logic of Social Security is you've got to prove, and again, there's something called the burden of proof that changes at some point, but big picture, you've got to prove that you meet their definition of disability, which is vocational in nature, that you don't have the capacity to be reliable and dependable at really any kind of job. But then but if you're over 50, it's a little different. If you're over 55, it's a little bit different. If you have, physical limitations, you can use the grid rules, but you can't if you have non-exertional limitations. So it gets very, very confusing. So the reason why we do these live streams and videos and other informational channels is so people will know, because if you're not able to work, there's really not one place to go for really accurate information. So it's our pleasure to share this because we want people to know. I mean, this can be life or death. It really can be. So but thank you for your comments there. Hey Larry, how are you doing? My pleasure. We got a favorable in Larry's case, which is always a nice thing, and I'm glad we did. And good to see you here. Thanks for tuning in. Karen D. In San Jose. I've been waiting for recon since May 6th of 25. Okay, well, this is an interesting question. You're doing some gig work under SGA, and it's causing your disability to be worse. Should you update SSI? Should you hire an attorney? Elyse, take it away. What do you think?
Well, if you're waiting for it, I mean, I would let them know that you are working, that it's less than 6 hours a week. I mean, just because you don't want to hide things like that. You don't want them to find you when you actually have a hearing, that you're not credible, that you're not disclosing this. So something like that, I would want them to know. And I do recommend hiring an attorney rather than doing things pro se, because I do think that, you want someone to be your advocate. And this is so specialized. You want someone who knows what they're doing. And
yeah, you don't really want to, it's hard to dabble in this. And I know when I started doing it, at first I was doing, a long time ago, started doing a little Social Security. I was doing bankruptcy and other things. And I realized pretty quickly that you can't dabble in this. It's just there's so many little rules and practices. And back then we were all doing live hearings, and the judges would kind of get to know who you were. And, if you came in unprepared or didn't know what you were doing, pretty obvious. And like you were saying before, Elyse, you get a reputation. So I think you got to sort of either do this or don't, but you don't want to dabble in it. I think that the one point you made here is that your gig work, and you don't say what it is. I mean, whether it's driving Uber, a lot of people do that. And by the way, if you're doing gig work and you're doing it, let's say you're getting paid every week, realize that some months have 5 weeks, some months have 4 weeks. So you got to really watch that, watch those gross earnings to make sure you don't go over SGA. It's not a big deal if you go over, once a year or twice a year. But if you're consistently really close or over SGA, that can be potentially a problem. 6 hours a week, it depends on what you're making. Again, if you're making $35, $40 an hour, you could be, well over SGA for that. The fact it's causing your disability to be worse, again, let's say you're driving Uber and sitting in the car, your back is getting worse and worse. One point would be that if you have to buy a back brace or some sort of a special seat cushion to help you perform that work, that would come off the top when it comes to figuring out your earnings. So if there's any expenses that directly relate to, medical needs that would allow you to do the work, that would reduce your earnings, when it comes to an SGA calculation or substantial gainful activity calculation. Second thing is if you have necessary business expenses, let's say you're driving a car and you got gasoline and tires and oil changes, those would come off the top too. So, that's a little bit beyond what I want to go into now, but when you do report it, you might want to just research this or think about what your expenses are so that what you report is really more reflective of what you're actually doing. It's not the gross before medical accommodations or before expenses of business. So you may be much less than SGA, even more so than you think. And as far as notifying them, I know that after you're approved, you can go to your My Social Security account and do it there. What I would probably do is there's a form called the 795, which is called the Statement of Claimant or Other Person. And you could put it on the 795 that, is basically a statement you're signing off on that as of such and such a date, I started doing this work. I would try to keep track of week by week what you're doing, but mention that, that the work you're doing it for economic survival, but it's making your back pain, knee pain, whatever, it could be mental health for that matter, worse, that your earnings after factoring in these necessary expenses are much less than SGA. But, as Elyse said, you want to be completely transparent with Social Security. I think that would hold you in good stead, if you get to a hearing. As far as a lawyer, my feeling has always been at a hearing, you don't want to go to a hearing without a lawyer. I think that would be foolish. There's an old saying in law school, he who represents or she who represents himself or herself has a fool for a lawyer. You don't want to do that because it's very hard to, step back and be objective. Initial and recon, there's benefits to having an attorney. I talk to people. I talked to a guy today, and he's already filed his recon. He's waiting for a decision. I said, let's just wait for your decision. And then if you get turned down, hire me. No reason to pay an attorney after you've already filed if you hadn't gotten your decision yet. So, but I think if you're at the point where, again, you've got questions here that may call for legal analysis about this SGA question, depending on where you're at, it might make sense to at least talk to an attorney, have somebody lined up. So that's how I would answer that.
Oh, Jonathan, I just want to point out
Yeah.
that for 2026, the substantial gainful activity amount, the monthly amount, has to be less than 1690.
Yep, gross. But and again, that people and realize if you're looking at previous years, that if you go to you just type in SGA in 2025 or 2025 or 26, you'll go to the table. It'll show you, I think it was 1620 or 1610.
1620 in 2025.
Okay. So if you're looking at SGA in previous years, it won't be 1690 like it is in 2026. And that, by the way, is about $20,000 a year. So we're not talking about a lot of money. It's still really, really low, especially if you live in New York or Los Angeles or Chicago or Atlanta for that matter. That's not a lot of money. It may put food on the table to some degree, but it's not a lot of money. So, it's tempting to want to go over that. And certainly if you can make enough money to support yourself, you should. What I get concerned is when somebody is earning, let's say if SGA is 1690, if they're earning $1,800, if they're earning $1,900 just over SGA, but really not enough to survive. So you don't want to sort of be in that in-between state. If you're able to earn $3,500 a month, $4,000 a month, okay, not a ton of money, but at least you can survive on that. But you don't necessarily want to be just over SGA month after month because, like I said, that's going to put you out of the Social Security world, but not enough to really survive. Other point I would make about earnings while you're applying and the SGA amount, yes, it is 1690 in 2026. My opinion, my experience has been if you are consistently earning 1680 every month, a question will be raised in the judge's mind. Could this person with a little more effort be over SGA? Agree or disagree?
Absolutely agree. I've had that issue.
Yeah.
When I was working at the hearing office.
Because it looks like income suppression. So you got to be very careful about that. Again, this is where an attorney can be helpful, as Elyse said, making decisions about, earnings and what that means. And, we would never tell somebody stop working, if you can possibly work. But again, if your earnings are, if there's a difference between earning $1,800 and earning $1,500, and everything else being equal, and you want to pursue disability, you need to be aware that $1,500 is going to keep you in the system. $1,800 could potentially push you out. A decision you've got to make, but you need to have that knowledge so you can make a smart decision. How to figure out what your earnings are for SGA purposes. That's a kind of a legal analysis. How to update SSA. Again, realize that they'll see it at some point on the tax returns. They'll send you a form saying, explain this. How do you fill that out? These are the sort of things that, having an attorney assist you with wouldn't necessarily be a bad thing. So there are reasons to bring an attorney in early on just for things like that, because these are not common sense kind of questions, and you make the wrong answer, you put the wrong answer, it can really create a problem. I have a case right now coming up for a hearing in a month, I think, and my client, put down an onset date that was, I can't remember the exact months, but let's say she put an onset date of February of 2024. Well, her date last insured was December of 23. And it's a Title II disability case only, which means that her onset was after her insurance ran out. Well, that's a problem. So I called her up. I said, look, we don't have a case. I mean, you have an onset date after your date last insured. And she said, well, my problem is going back, well before then. I just, I was working kind of part-time and it wasn't SGA, but that's when I finally just stopped working. Well, in that situation, she had work attempts that were not SGA prior to her date last insured. I went ahead and amended the onset date to a date prior to her date last insured. Now, again, the judge is going to have to make a determination as to whether that's legit, whether the judge will accept it. We have not a high approval judge, so that's going to be a challenge, but at least I have her in the ball game, because she misunderstood. She thought that, she could not apply for disability until after she completely stopped all work, but working, 1 or 2 days a week and doing it for 3 weeks unsuccessfully does not mean you're able to work. She didn't know that. So this is, again, an area where having an attorney advise you about that could really make a difference. So, just cautionary tale that you don't want to assume things, you don't want to guess on things like that. All right, KU Thunder says, hello, Jonathan, Elyse. Thank you for sharing your expertise. You are very, very welcome. All right, Lady J, Self-Care and More. It sounds like a business. Okay. I'm in the process of waiting to hear a decision from the Appeals Council. I was able to disagree with the decision and send in documents. And now my lawyer has ghosted me and I haven't heard back from him since. What do I do about that? How long will it take to get a decision? What's your take, Elyse? I mean, you say he's ghosted you, but we can talk about that in a second. But you're waiting to hear a decision. What should Lady J do?
I'm sorry. So I was able to disagree with the decision. So you
had a lawyer write the appeal.
Sent in documents. So the attorney sent in documents. I mean, you're just waiting for the Appeals Council to issue a decision.
Yep.
So it just sounds like it's waiting, and there's really nothing for the lawyer to do until a decision's issued by the Appeals Council.
Yep.
So I don't really know if the lawyer is ghosting you or just there's
waiting.
nothing for them to say.
Yeah. So I think what we're saying is that it may be that there's nothing for the lawyer to tell you. You're waiting for the Appeals Council to make its decision. So, there's nothing for the lawyer to tell you. Now, the lawyer should probably at least respond to you by a quick email. We're still waiting. Not responding is not a good thing. I would say this, that if the lawyer is not being very responsive, it is complicated to change lawyers. I will tell you, Social Security does not make that easy for many reasons. But many lawyers, if they do Appeals Council work, they don't all do federal court work. I mean, I don't really do federal. I mean, I'll bring on somebody to do federal court work. I'll associate. I don't do it on my own. I just don't. It's a different practice. I don't have the time, expertise, resources to really do it. So I'll bring in another attorney. And so it may be that your lawyer has discussed with you, or you could raise the question, if we're denied at the appeals council, will you release the file so I can get a district court litigator? So I would say this, I would reach out to your lawyer, if you need to do it by registered mail, return receipt requested, saying, okay, you filed a brief, you submitted documents, you did all the things you're supposed to do, we're waiting for a decision. Can you tell me anything? And if you can't, if you're no longer doing this practice, I need to find somebody else. I got to start doing that. Will you let me know that as well so I can look for somebody else? So it's pretty rare that you would be, quote unquote, ghosted by a lawyer after the appeals council brief has been filed. That it could happen, but it just seems kind of unlikely to me.
I agree.
Yeah. So, but I think, it gets, if you write your lawyer a physical letter, fax them something, try to find somebody in his staff or her staff, get their attention. I mean, look, lawyers in this practice area are busy, a lot of cases. I mean, and sometimes if there's nothing to tell somebody, it's going to be, you're not going to want to spend a lot of time on the phone saying there's nothing I can tell you. I mean, email is a really good way. A lot of, like we have, I know you use Clio, I use my case. We'll send a message. So make sure they've got your updated email address, phone numbers, all that kind of stuff. They can communicate with you. And maybe just a simple, hadn't heard anything yet, we'll let you know. And that will be sufficient. I don't know that a phone call from your lawyer saying, I haven't heard anything is necessarily you're going to happen, because it's just time is so precious for a busy lawyer, but they should respond to you in some way. Wow. Had an omelet. I don't know why I'm coughing like this. Shouldn't be coughing like crazy for an omelet, but I did have some popcorn with the omelet. I will acknowledge, and that could do it. But okay. Hey, Christy, how are you doing? Good to see you here again. Hello, everyone and the guest. At least you're now the guest. Okay. Is there some type of funding while you wait for SSDI? I would say mom, dad, brother, sister. There is no funding. There's no partial disability. There is an SSI, presumed disability. You don't see it very often, but there is a way to do it in SSI. But SSDI, no, unless you've got family or friends, there's really nothing you can get from Social Security, to my knowledge. Are you aware of anything? I don't know of any way to get. Just have to wait. It takes a long time.
Food stamps. I mean, just taking out bank loans. That's what one of my claimants have done.
Yep. Okay. Sorry about that. I hit the wrong button. I don't know why. I went blank there for a second. Okay. Robert Godwin says, I'm a great candidate for Grid Rule 202.02, which means you're 55 and over, you have less than a high school education, and no transferable skills. At the recon level 55 in April. Okay. So you would be a candidate for Grid Rule, in April, or maybe a little bit before then if we use that PALMS regulation. Bad right leg and weak on that side. Should I feel optimistic for a favorable decision? Honestly, Robert, it's going to depend on what the medical evidence says. A bad right leg, what does that mean? I mean, is it do you have vascular problems? Do you have orthopedic problems? Or is there a knee issue? Does it more specifically, does it limit your function? Does it limit you walking, climbing, bending? What exactly does that mean? And weakness, what does that mean? Have you had any sort of test? Did they send you out for neurological testing? Social Security will send you to a consultative doctor for neurological testing. What did that show? So, I think that certainly being 55 helps you. Certainly having less than a high school education helps, makes it a little bit easier. And I think, if you have a bad leg and there is some diagnosed functional limitation at 55, there's a pretty good chance that a judge is going to look at it and say, I can't see this person doing more than light work being standing and walking 6 hours, which may be a push for you, or lifting more than 20 pounds, because the next level up is called medium work. And that would be standing and walking 6 hours, but lifting up to 50 pounds. Well, if you have a let's say you're in need of a knee replacement, or you've got swelling in your leg, DVTs, which is a blood clotting in your legs, or you have, you've had some injury, or you have significant weakness that affects you. You have a bad limp, or you can't climb stairs, or you've got torn hamstrings or Achilles, whatever it may be. I think that, I think most judges would probably find that light's going to be kind of difficult. So I would be cautiously optimistic, but it's going to depend on what the medical evidence says, is my take on that. Hey, Julia from Georgia, one of my clients. How are you doing? Glad you could tune in. Good to see you. Okay, please change the screen to what it was before so we can horizontal. Okay, I don't know if I can do, let's see. Well, there we go. We got bigger there. Let's see. Let's see if this, no, we don't want to do that. I have all these different options here. This is, I know sometimes people, and I think you've told me this, I know who this is. And again, I'm very careful. I don't like to discuss my clients' specifics, obviously in a live stream. But this person was telling me that when she was watching the, on YouTube, it was defaulting to the vertical placement as opposed to the horizontal placement. So if you're watching this on Instagram or on YouTube on a phone, you'll see the vertical placement, which means that the comment is above our heads. I'm looking at it my end here. If you're looking at it on more of a horizontal placement, it's going to be Elyse and myself and two screens next to each other with the comment on the bottom. So I think that we talked about this, the poster and myself, that for some reason your computer or your laptop is defaulting to the vertical alignment. So if there's and I don't want to diagnose your computer, but that's what's going on, I think. I don't think that other people, tell me if other people are seeing this. Are you seeing Elyse and myself next to each other with the comments on the bottom? That's what you should be seeing if you're watching this on a laptop or a computer. If you're seeing the comment on the top, you're probably seeing it on a phone or an iPad or something like that. Okay. Okay, so Giggly or GGL says the retirement trust fund's running low, not the Social Security disability. No, I think they're both running low, if my understanding. I think they're both running low. You can look that up, check with Google, but I think both of them are running low. Julia, okay. All right, Julia, again, is one of our clients. Under the reconsideration, about to fill out another function report, should I add new ailments that you've not been to the doctor for? I would say yes. I think that, the purpose of reconsideration is for Social Security to revisit the decision. But if there's something new, I know in the reconsideration disability report, they ask us specifically, is there something new? So if you're filling out a function report, add what's new. Now, if you haven't been to the doctor, you still can add it because that may trigger a consultative exam, or it may trigger the adjudicator, if you're fortunate, that would say, okay, there's something going on here. But I would say it would be to your benefit to get to a doctor to treat that particular condition, sooner rather than later. And tell me if you ever saw this happen, Elyse. I remember one time years ago, I had a client at a hearing, and we get to the hearing and he started talking about, let's say, breathing problems. And previously it was just back issues. And the judge basically says, I'm going to stop the hearing right now. And I'm going to send this case back to the state agency for development of the breathing problems, because that was never brought up before. Have you ever seen that happen?
Was there any breathing problems in the just medical records?
Not really.
Not in
really.
the
It was basically brand new at the hearing stage, where the judge did not even consider it, dismissed it, and said, this has to be developed by the state agency before I can consider it. Now, this was like 25, 28 years ago. Would something like that still happen? I mean, I haven't seen it since, but
I would maybe, because it's, I would look at the treating records. If there's no notice in the treating records, and, the person's insistent that they have, some sort of another impairment, then maybe they would send them out to a consultative examiner.
Yeah, but they wouldn't send it back for another I mean, they wouldn't send it. What this judge did, he sent it back to the state agency to recon, basically, to say,
No, I wouldn't do that. I mean, normally
yeah,
they send it to the state
for
agency
consultative.
to set up the
Yeah.
consultative examiner.
Yeah, but at the hearing office now they can do. So basically, what would happen in a situation like this, Julia, is if you fill out the function report and you say, I now have DVTs, or I now have breathing problems, or I now have, some new condition, whatever it is, heart problems, you have atrial AFib. The judge might send you out for a post hearing or or the reconsideration. Forget the judge; we're not there yet. The recon adjudicator might send you out for a consultative evaluation to evaluate that newly claimed condition. And of course, if you have your own records, those would be helpful as well. But yes, I would add, the answer to your question is yes, add that. No question about that. You definitely want to do that. And if you want to send it to me to review, happy to do that too. That, I'm not a big believer in filling out forms because I don't think I should be creating evidence. But if you want me to look at it, send it to me and I'll be happy to look at it, give you my 2 cents. Okay. Elyse, you can take this one. Do people over 60 have a greater chance to be approved for SSDI? My vote is yes, but what's your take?
Because of the grid rules.
Yeah. Isn't even more than grid rules? Is there not kind of a built-in bias in the system?
Well, they don't expect them to be able to learn new jobs. I mean, it's harder for someone over 60 to
Hey! No, let's
and
not,
new skills.
let's not get personal here. I can learn new stuff. But
yes.
Yeah. So I think what we're saying is that if you're over 60, obviously the grid rules, if you've got something exertional, I realize the grid rules only apply if you have an exertional or physical impairment. You cannot use the grid rules for depression, for example. You have to have something that limits you physically to a light or a sedentary exertional capacity. But my experience has been, like Elyse said, that if you're over 60, even though you may not meet the grid rules, let's say you've got a depression case, judges are going to look at you and say, this old fart here is going to have a really, really hard time learning something new. Their minds are not as agile, and they can have a hard time with computerized things or learning, new skills. You've been doing, let's say packing work in a warehouse. You're now going to be expected to go to a office and do, office clerical work. Probably not. Handle a 15-line phone as a receptionist. Probably not. So I think I would go so far as to say there is a built-in bias in favor that benefits people over 60, really over 55, but especially over 60, because realize with the grid rules, if you are limited to sedentary or light, that enhanced transferability of skills standard applies specifically. And even if it doesn't apply under the grids, I think it's still the premise of it still would apply as well. Okay. Good question here, Brian. At what point in the process, the procedure, do I send in medical records? How do you transmit them? I'll give you my take. At least you give me yours. You can obviously mail them in. If you can get what they call a barcode from Social Security, you can fax them in. They, believe it or not, still use faxes quite a bit. You can fax them in. You can hand deliver them to your office. And if you have an attorney, your attorney can do it electronically. As far as whether you should send them in, that's a different question. Now, we had a few weeks ago or a couple months ago now, I had a woman who was a former adjudicator at the time. She was an active adjudicator. She later on left and she no longer with the agency. She told me she told us in our live stream that their preference was not to have people send in records. They wanted to get them themselves. But other people differ. What's your take on that, Elyse?
As long as the records are in there, that's all that mattered.
Okay.
You want the records to be in there. It doesn't matter who submits it.
Yeah.
Obviously, if the doctor sends it, it's complete. Where sometimes you have to wonder if a claimant is sending it, maybe they're not putting the complete record in.
Yep.
But I would put it in.
Yeah. Well, I mean, the point that they're, and again, this is on a previous live stream. I think she used the name Linda, I think is what the name she used. And I'm going to try to get her back on because she's now no longer with the agency. She can tell us the real inside scoop here. But she said that her concern was twofold. One is she wasn't as that concerned about people scrubbing the records and taking out references to their drug use or incarcerations or things like that, because that stuff will come out eventually anyway. But she said the bigger problem was that she would get records that were sort of partial records, where they were from a portal, and then she'd get the records directly from the doctor that was duplication. She would have to dedupe the file, and she said that was a very time-consuming process. So her take was, unless she wanted it, she called up the lawyer or the claimant and said, send them in because the doctor's not cooperating. She wanted to get them herself. That was her take. Now what Elyse is saying, and I think there's logic here too, your interest as the claimant is to get those records in one way or the other. And, if it means they've got to spend time deduplicating them, then that's their problem. You want those records in. And the problem, if you're not represented, is you don't know what they've got. Now, as a representatives, attorneys, we can look in the electronic file, and say, okay, this file is being worked up. This is what they've got. We know what they've got. We can tell, but you wouldn't know that. So after Linda told us that they didn't really want people to do it, I was telling people, you probably don't want to necessarily do this. But I'm kind of starting to swing over a little bit to say, you know what, you got to do what's right for you, and get those records in is more important than, the work time frame of an adjudicator someplace. So, I think that you at least make a good point. Get the records in. Get the records in. PMFG. Can someone with a listed disability condition apply prior to the age of 65 if SSDI cuts them off at 56 after allowing benefits since 01? Okay, it's a little confusing question. I think one question would be, are you still insured? Do you have credits? So what you're saying is that you are cut off at age 56 and you are now at some point in your 60s, and you're past what they call the extended period of disability. If you reapply for disability, I think part of it's going to depend on your onset date, because you need to find out what your date last insured is for disability. Because if you don't have insurance credits for disability, you can't recover benefits. So what it sounds to me like was you got benefits in 2001, you were cut off at age 56. That's been several years. Now you want to go back and say, I've got proof of a listing level condition, something very serious. You probably are disabled. Let's assuming that's all true, but you probably don't have enough credits at this point. And so you could pursue SSI, but I don't think you're going to get SSDI unless you're still insured. Maybe you worked and you built up more credits, but that to me would be the big issue, is do you have enough credits for being insured? Okay. All right, Chanset says, hearing went well, waiting for the approval, 6 to 8 weeks. That's been my experience, 4 to 8 weeks, sometimes faster, sometimes sooner. Have you heard anything, Elyse, about the time frame for getting decisions out? Does that sound about right? 4 to 8 weeks?
Well, when a lot of the decision writers like me took early retirement, you have less people to write decisions, and you also have less judges. A lot of judges retired.
Yep.
So I personally think it's going to take longer, but I really don't know.
So with the decision writers, you said some of them, I want to make sure we didn't zoom past that.
With the administration, they offered voluntary early retirements.
Okay.
So a lot of judges took it, and a lot of decision writers, whoever was eligible, a lot of people took it. And then they're even more short-staffed. Yeah,
and they're telling people, in certain areas to man the phones now, because they're trying to get the phone, the metrics down on that. Instead of taking an hour to be waiting on the phone, they get people that were in the hearing offices doing XYZ, or not necessarily hearing offices, but certainly the state agency offices manning the phones. So, yeah, I mean, I think, what is it down like 30% or something over the last couple of years? It's crazy how many people that they've lost.
Oh, they lost a lot, and they lost a lot of institutional knowledge.
Yes. Yeah. That's actually, talk about that a little bit. That's actually a very good point. A lot of people don't think about just the numbers, but when you say institutional knowledge, what do you mean?
You have someone like me, I've worked there. I used to train people. I was a mentor. I've done details. I was in, the imaging training. I did a detail with, doing continuing disability reviews. So I come in with this knowledge and, I'm able to help to mentor younger decision writers or people who haven't done anything, or, I'm able to answer questions. And so I leave. There's no one who can act as a mentor to to people who are younger or who have no who have just came on in the agency. And again with the judges too, you had older judges who would mentor newer judges, and they've left. So you have the newer judges who are here who don't have that experience. And so,
Thanks,
they don't have anyone to turn to
yeah.
if there's a decision, if there's an issue that they're not sure quite how to handle.
Yeah. Well, look, I mean, I will tell you, I've appeared before a lot of different judges, and there is a big difference when you have a judge who really knows what he or she is doing. They run the hearing. They've got a boom, boom, boom. They know what they're trying to get at. They don't waste a lot of time. Then you have judges who are less experienced, and they're like following a script. I'm like, what are you wasting my time? I mean, I would never say this, but you're wasting everybody's time. We don't need to deal with that particular issue. I mean, they're asking about past work 15 years ago. Well, that's not relevant anymore. Or they ask a hypothetical question that, it reflects the state agency's determination that they were not disabled. I mean, stuff like that, just, you can sort of tell they're very unsure of themselves. And you try, obviously as an attorney, you got to be polite and professional and so forth, but it's pretty obvious when somebody's brand new, and it's a little cringy, I would say. All right. Well, going back to your question. So our take, Chan, is that you may be looking at closer to 8 weeks. And I'll tell you, I'm looking at, my hearing calendar from November, December. I got a bunch of them still out there, and they're very, very slow in coming out. I got, there should be many more decisions being issued. They're just not, because they're just so backlogged. Okay. So you got approved today. The judge, you went on the record. The judge says the evidence is overwhelming. You don't need testimony. That's great. That's what you want. You're approved. That's exactly what you want to happen. And I always tell people the best hearings for me are the ones where I don't say anything. I just keep my mouth shut. One thing you learn as a lawyer early on, that if you're winning, keep your damn mouth shut. Because, if you're winning and the judge says you have anything to say, nope. Had that, happen today. The vocational testimony wasn't my favorite. Judge says, any more questions, Mr. Ginsberg? Like, not saying a word. I know that I won, so I'm good. I'm good. Thank you very much. Okay. This is an interesting question. I don't know if we have an answer to it, but we'll ask it anyway. Courtney was supposed to have a psych exam with certain types of testing at the administrative level. They called and said canceling that appointment. Then they denied her case. Can you ask for that exam in the appeal? Does that question make sense to you, Elyse?
I've never seen anything like that happen before.
Okay. Well, and I have seen it happen a couple of times. I mean, the answer to your question, my opinion would be, the fact that they scheduled you for an appointment doesn't give you any specific rights. But I think in your appeal, you could make reference to that Social Security did not properly develop the evidence in the file. They had scheduled you for a CE, then they basically canceled it. You want that CE. You can't force them to give it to you. You can't force them to send you out to one. But I would put on the record in your appeal, and if you have an attorney, have your attorney do it, that this case was scheduled for a CE and it was canceled, for no specific reason, and there are mental health issues that need to be properly developed. My experience has been, and at least you may have a different one, but my experience has been that consultative evaluations, mental health consultatives, are either going to be, most of the time, either neutral or somewhat beneficial. It's rare in my experience that a psych CE is going to hurt you. unless there's malingering or some other, something else like that. But usually they help you. Any thoughts on that?
I agree. They
Yeah.
find something that they'll find some sort of limitation, and then that can be used in the RFC, residual functional
Correct.
capacity finding,
Correct.
to show that
Well,
there's some sort of mental limitation.
yeah, I mean, I think that, the psychologists that are on the panel for the consultatives are typically practicing psychologists. They see patients and they do this, make a little extra money. A lot of the doctors who do the physical consultatives are kind of these, industrial clinic, doctors that do these, not all, but many of them are. They do these exams for insurance companies, who do them for Social Security. They don't really have a regular private practice, but a psychologist, they're trained to find a problem. And again, if you want to be cynical, it's because that's how they make their money. I mean, they want to treat people. If you go in to see a psychologist, how often are you going to hear, "Oh, you're perfectly fine. You can't blame you're not blaming your mother for anything. Therefore, you're perfectly fine." They don't do that. They're going to say, "Let's talk about this." At $200 an hour, and then we'll see you for the next 2 years, and you can talk about how your mother screwed your life up. I'm being a little facetious, but that psychologist, that's how they make the money, is to treat people. So my experience is the psychologists and the CEs are probably going to find something that could be beneficial to you. So I would, to answer your question, Courtney, I would reference the fact that they canceled it. It may or may not move the meter, but I think it's relevant. And, you could even at a hearing, if you got to a hearing, say, they didn't develop this record properly, if there's some weakness in the case. And if you can't afford to go to a psychologist, you can say, they were supposed to send me out to one. There's a reason for it. They didn't do it. And, Social Security, you've got an obligation to develop the record. And they might send you out then, after the hearing even. All right, CDRs. You know more probably about CDRs than me. I don't know if you have any. I'm sorry?
When I did the CDRs, it was for pro se.
Okay.
So
Okay.
they brought us in. There were 50 of us decision writers nationwide who were chosen to do this detail, and we were brought into certain states to help out. And each state had different rules, so it does depend on the state. But we were doing pro se, and when we were doing it, we were developing the records. So we were contacting the doctors. We would have conversations with the claimants and say, who are your doctors? Have there been any improvements? And we would then, send out for the medical records, and we would also send people out if there were no medical records for consultative examinations. So
No,
you really need an
now, one thing I didn't understand about CDRs, because people get these forms, the short form and the long form. And my understanding was that if they fill out the form, and let's say they fill out the short form and it says the doctor thinks there's been improvement, or they've worked, or some reason for it to seen by a human, or the long form comes in and it suggests maybe there's a medical improvement. What happens then? Is it go to the state agency? I mean, where would you be involved? That's my question. At the hearing stage?
It was at the state agency.
Okay. So you're working with the state agency at that
I was working with the state agencies.
Okay. So essentially it goes back to like an adjudicator to evaluate the case as if they were doing it at initial or recon.
Right. So I was just, they had a bunch of attorneys like me acting as disability examiners there. So we were acting as adjudicators. We would look through the medical records. We would develop the record, look through the medical records, send it out to a state agency doctor. And the doctor would say, yes, the disability continues, or no, it doesn't. And then, it should be seized.
Okay. And the reason they would say that this disability should be stopped would be medical improvement, I'm guessing?
Medical improvement.
Okay.
Or a person went back to work, and, obviously this medical improvement.
Right. And were there certain conditions that Social Security kind of assumes there'll be medical improvement on, or is it case by case?
You're looking at the case by case.
Okay. I mean, like I always thought that if somebody, let's say at the hearing, they're talking, they've got a back problem and they're supposed to have a fusion, 3 or 4 months down the road, the judge might, and this is again another question. In that situation, would a judge flag the case somehow for a 1-year review or a 3-year review? How does that? How do judges? What's their involvement in determining when the case should be reviewed?
Age has a lot to do with it.
Mm-hmm.
So I had a case where I had to have a younger individual, and I said, let's do a 2-year CDR because he wants to go back to work. He's going to have surgery. He's going for physical therapy, and we expect there to be medical improvement. So let's give him a 2-year CDR. I recommended that, as an advocate because it was reasonable. But someone who's older,
Meaning 50 and older, would you say?
50 and older, usually there's not going to be medical improvement. So, so there, you may not have to do a CDR. The judge may not, usually when they're older, the judge is not going to say, give him a 1-year CDR or 2-year CDR, but usually it's for younger individuals that they get that.
Is there some sort of a code that judges put into and maybe you don't even know, that they put into the decision or let Social Security know about that would trigger a CDR?
Yes. So in the instructions, the judges will say, give a 2-year CDR. And so we would put in the language, I recommend a continuing disability review in 2 years.
But if it's because I don't see it in a lot of decisions. I mean, I do see it occasionally, but I'd say the vast majority I don't see it. Is there some sort of a hidden code someplace?
No, it's usually at the bottom of the decision.
Okay.
Right, right before the judge's signature.
Okay.
I recommend a continuing disability review.
Okay. If you don't see that, it's your knowledge. Is it just how do they? You said a lot of it's based on age. Is there some sort of an algorithm or a procedure within Social Security to determine who gets reviewed?
And well, supposedly all cases are supposed to be reviewed at certain, after a certain number of years.
Right.
But there's just not enough people to do it.
Right. So the age is going to be the main factor.
Age is, if a judge puts in because of the age, that's going to be, one of the triggering factors, and that'll take precedent over some of the other cases.
Okay. Let me ask you this question, because I always tell my clients doing hearing prep that it's really important to show, basically not to show an attitude of entitlement, to show an attitude that you're a fighter, you hate the idea of pursuing disability, you want to go back to work. Do judges pick up on that? Is that something that's important to judges?
Well, when I was at the hearing office, we had a person who went in and said, I'm entitled to this benefit. I'm entitled to it. And quite frankly, it angered the judge because no one's entitled to it.
Right.
You have rules and you have to meet these conditions. So you don't want to come in with an attitude. You want to be respectful and you want to be honest, and you just, no one's entitled to these benefits.
Yeah. And I've had people say to me, I worked all these years, I paid it in, I want my money out. And my response is, it ain't your money. They don't call it to consider it your money. They consider it to be their money, and they're going to fight you every step of the way to give it back or to pay you out, but you don't have any right to it. At retirement you do, but not at disability. They got it. You have to prove to them that you are disabled. So, okay. Okay, this is a good question. How much weight does the ALJ give to the consultative evaluation versus let's say a primary care doctor versus a specialist? What's your take on that?
It depends on the judge. Some judges, I worked with a judge who was just like, I'm not going to rely on this, 20-minute exam by a consultative examiner. The primary doctor, what they write is much more important. And then we have some judges who say, well, they went for an examination and the consultative examiner said he can sit for 2 hours and he can stand for 4 hours and he could walk for 2 hours. But the treating doctor did not give a did not give an RFC, residual functional capacity. He didn't state the limitations that the claimant has. So we're going to go by what the consultative examiner said. So it really depends on the judge, how much credit they give to the CEs, and what the treating doctors say. I mean, if your treating doctor is going to, if your treating doctor puts in a residual functional capacity and says, he can stand, he can walk for these hours, and gives the limitations, that's going to give a lot more credit. And, the judge is going to consider that.
Were you with the agency when the Eric Kahn situation arose?
Yes, but, I was in New York, so we
Right.
didn't have to deal with
I'm
that.
just wondering what effect that had on the overall agency in the disability process.
I just remember lots of internal memos on that,
Okay.
but I don't really remember, I mean, I know there was made some changes, but
Yeah. Well, and for those who know what I'm talking about, there was a lawyer named Eric Kahn, C-O-N-N. In fact, there was, I think, a HBO special or Amazon special about him. And he had a setup, and he was in like Kentucky or West Virginia or someplace, in Appalachia, where he had like a judge on the payroll, and he had maybe an adjudicator, and he had a doctor. And basically he was just pushing these cases through and making millions of dollars, but it was fraudulent, because he was paying people off. And of course that fit the narrative in Congress that, everybody on Social Security is faking it or exaggerating it. So what I saw was, it went from about a 60% across the board approval at hearings to about 40%. So it was a dramatic change. And it's kind of inched its way back up to about 50%, but it caused a lot of problems in terms of the way judges were being scrutinized. There was a lot of congressional testimony. Judges with high approval rates were being pushed out. They were being, just really hammered hard in Congress. The judges with the really low approval rates drew a pass for some reason, but the ones with the high approval rates were being really, really challenged. So it was not a good time for Social Security. And like I said, it seems to have gone past that. But yeah, it wouldn't surprise me, a lot of internal memos. No question about that, because there was some changes for sure. All right, so Low Gambit, this is the person who thinks that maybe 202. Yeah, if it's legit, then go for it. Then absolutely go for it. Right, thankful for, and I think a lot of people feel that way, and I think many people feel like if they could go back to work, they would. This is not something that any of us, when we're growing up, think, well, I hope that when I'm 53, I'll be on Social Security disability. I mean, it's not a lot of money. I think that you lose the socialization element to it. I mean, many people, their friends are through work, your identity, I mean, who you are is what you do in many cases. And if you go from working and, hanging out with the guys or the ladies, and you grab a beer and you go to the ball game, and all of a sudden you're not working, you're no longer part of that crowd. And I think it can be really psychologically devastating. So most people don't want to be on disability, but if you have no choice, you got no choice. So Deb from Iowa, how are you doing, Deb? Not a lot of people from Iowa on the live stream for obvious reasons, but good to see you here anyway. And this is the person who just got approved. Do you have to get I don't think you have to get a placard. Realize a handicap placard is something that is issued by the state, and typically you have a doctor write fill out a form, but that's not really going to determine anything about your Social Security disability. It could be evidence, but you don't have to get one if you don't need one. Okay, we already talked to Karen there. Let's see here. All right, we got Azure 6. Thank you both. You're welcome for both. 49. RFC case, meaning that obviously there's no grid rules there. Initial stage, marital records are noisy. 20 conditions. Writing an attorney level packet to focus on my case. What mistakes do you see when people are doing this? I'm going to give you my take, and we'll see what Elyse thinks. I think that if you're putting together your information packet, if you want to call it that, the medical evidence, I would focus on 3, maybe 4 conditions that are the primary reasons why you're not able to work. I think if you start talking about 20 conditions, I think that's going to just be distracting to the adjudicators. I think, you can mention those other things, but, there's probably going to be 3 or 4 that are the most vocationally significant. That's one point. Second thing would be related. The conditions that you want to focus on are the ones that are going to limit you from being reliable and dependable. Example, I see sleep apnea in a lot of cases. I have never won a case solely on sleep apnea. Now, it can contribute to an approval, but generally speaking, my experience has been, and at least you may have a different one, that judges are not going to decide that somebody is disabled because they have sleep apnea. They may limit them to unskilled or low-end semi-skilled work in the hypothetical, but sleep apnea is sort of considered to be kind of a annoying but somewhat manageable condition. There's CPAP and there's other things that you can do. Many times they'll say lose weight, which again, easier said than done. But that's not a condition that I find is typically truly disabling, or judges find. Same with non-insulin dependent diabetes. Most of the time, unless you've had it out of control for a long time, if you're not insulin dependent, it's perceived to be a kind of a chronic but somewhat manageable condition. So I wouldn't spend a lot of time on sleep apnea or non-insulin dependent diabetes. If you have a choice between fibromyalgia and a herniated disc, focus on the herniated disc, the conditions that are objectively determinable. So that would be my take. I would really focus on the things that are vocationally relevant. I would make sure you have a very clear presentation as to what your capacity is, and realize that this is really going to boil down in many cases to reliability. So that would be my take. Elyse, what's your take on it?
I agree with you. I mean, I've seen people put in 20 plus conditions, such as a hangnail.
Yeah.
And a hangnail is not going to prevent you from working. So you really want to focus on the most important ones and the ones that you have objective medical records, like the images that will show, look, there's a herniated disc. That's going to prevent you from sitting for long periods of time, for standing, from walking. So that, that will lead to work-related limitations.
Yeah.
Impairment like that.
And I think also, I mean, if you think about it, if you're a judge and you see cases day in and day out, and somebody has a herniated lumbar disc, L5S1, L4-5, and there's some nerve root compression, there's some stenosis, and the person's complaining of numbness in their legs or severe back pain, there's a consistency there that makes sense, right? If a person has, a non-insulin dependent diabetes, and they're claiming they've got, neuropathy to the point they can't feel their feet, they have retinopathy, they can't see anything, there's a little bit of a disconnect there. So, objective evidence is something that Social Security, my experience has been, really likes, because it can sort of be consistent with the nature of the impairment you're describing. I just think that if you have impairments that are not going to generally produce work preclusive impairments, that's just going to be noise, and use the word noisy. That's just going to be noise that's going to distract from those things that are vocationally relevant. That's my take on that. So answer your question, I would probably, instead of 20 conditions, you might knock it down to 3 or 4, and really focus on the vocational things. Tom, one of my clients, we just won. Yes, that was a good feeling. Let me tell you, Tom, I like writing those letters, not quite as much as you like receiving them, but it's really nice when I get to write a letter saying we won, and here's the attached decision. When should you expect a CDR? And again, I think as Elyse said, in your case, because of your age, I don't think you're going to likely be, and the nature of your condition, I think it's kind of unlikely that you'll see one. But if you do, obviously you continue to go to the doctor, continue to keep, track of the the issues you're dealing with, that obviously were ones that convince the judge, I don't think we're going to have a problem. Obviously, if you get a CDR, you let me know, but I don't think it's likely to happen. That's my take. Okay. Okay. So Walter Knott, again, who is very active YouTube disability attorney, a disability attorney who has a YouTube channel, does some really good work, and I've seen his stuff. I think it's great. And he's very prolific, by the way. He believes, I didn't see this one, but he said that they think that he thinks that Social Security may start requiring drug screens. What do you think? Do you think that's likely to happen, Elyse?
I have no idea.
Yeah.
I mean, I didn't hear anything about that when I was there.
Yeah. Yeah. I think that there already is a rule in place that says that if substance abuse is found to be what they call material contributing factor to your disability, meaning that if you stopped using whatever substance it is, alcohol, drugs, that your condition would improve, i.e. it's not a permanent condition. In other words, I've had alcoholics that have got, cirrhosis of the liver. They could go sober, but it's not going to change their liver function, right? So there's already that in place, that if they sense that you're, using substances, that would be grounds for denying your claim. And my experience has been, and of course I don't take these cases, but the few times I've slipped through, if somebody is actively using cocaine or even marijuana, although that's probably less of an issue now, but cocaine certainly, or crack or speed, things like that, those cases are probably not going to get approved anyway. I don't know that they can really. The trouble with drug screening is that people are on pain medications, so it may show narcotic pain medication in their system. I just don't know how practical, how they're going to have, who's going to do it, how they're going to have the time to do it. Yeah, I guess they could ask. And so what?
And the cost too.
The cost, right? I mean, you could ask consultative doctors to do it, but I think it's just not likely. What speaking of, I mentioned marijuana. What is, and you may or may not have an answer to this, but any sense on the way judges view marijuana use, A, either recreational, or B, a marijuana card that they've got because their state allows it, even though the federal government still considers it. I think that's changing now, but up until this point, a Schedule I drug. What was your experience with that?
Well, at that point, it was illegal when I was there, and then it became. I mean, in New York, it is legal, so they don't take it in. I would assume that they're not going to take it into consideration. They're not going to penalize you for it,
right? Unless it shows that you're using it recreational to the point where it is, interfering with what otherwise might allow you to go back to work. If you spend all day, playing video games and smoking weed, then that's probably, not going to put you in very good stead with a Social Security judge. But my experience has been that, and this long time ago is different, but now, since it's legal in most states, even though the federal government up until recently, I'm not sure if it's even gone through yet, considered marijuana, as crazy as it may sound, a Schedule I drug, just like cocaine and amphetamines, which is absurd. But that, if people were using marijuana, occasionally because they wanted to sleep or took some pain away or whatever, there was very few judges that would find a problem with that. They were actually, more judges had a problem with people who smoked cigarettes than who occasionally, smoked a joint. So I never saw it as a real problem, especially in states where it's legal. But again, you can't be a stoner, and expect the judge not to take that in consideration. And again, you still have this material contributing factor. A person, smoking weed all day long, that is not an acceptable use or rational use of marijuana. It's just like a person who drank. I mean, drinking alcohol is legal. You can go to a liquor store, buy, scotch and bourbon and so forth. If you're drinking all day long, you're an alcoholic, presumably, or close to it. If you're smoking weed all day long, you've got that same kind of addiction. All right. So Tom, I did not see anything on any of the documents that we got talked about a CDR, Tom. So no. Zippy says we need to get rid of the FICA tax. Yeah, that's going to be that's a political thing. Whether Congress, there's a lot of people who think it should be raised. Some think it should be eliminated. I don't see that happening. I think it'll get raised, but I don't think it's going to be eliminated. Let's see here. Okay. So you've got the right screen. There you go. Okay. This is a person who was looking at the screen that was vertical, not the horizontal screen. Can people on SSDI live outside the country? Depends on what country. Don't go to North Korea, which you probably don't want to go to anyway. I hear it's kind of cold there. But you can, in many countries, it's not a problem. There are a few. If you just type in go to Google, what country can I live in and receive SSDI? It'll tell you where you can go. Okay. Tom I would agree. Thank you, Tom, that, if you're going to do this, given that it's a 2-year process, but, there's a lot of places where you get tripped up, a lot of, traps for the unwary. So yeah, there's an argument to be said that it makes sense to have somebody work with you. And honestly, people will say, well, 25% of past due benefits, we get paid, by the way, as attorneys, with 99% of the time, 25% of past due benefits with a cap. Right now, the cap is $9,200. And people will say, well, I don't want to give up $9,200. I don't want to give up 25%. Okay. And you can do it yourself, but 100% of zero is zero. So, don't be penny wise and pound foolish. Yes, it's money, but on the other hand, there is value if you get approved when you otherwise wouldn't. Do I still have to pay your attorney fee? Yes. If you signed a fee contract, you do. And again, the attorney's work is, look, if anything, getting approved before the hearing is a good thing. And if your attorney's work led to that result, you should be happy to pay them. And again, I understand people don't want to pay attorneys because they feel like, okay, what did you really do? Well, if do you pay your surgeon on how much time he spent in the operating room, or where, or how long, how big the cut was? No, you pay him for his or her knowledge and knowing where to cut. So it's not a function of time necessarily. You put the right form in there, you say the right thing, make the right reference to a grid rule, that can make a big difference. So yeah, you still pay your attorney. You signed a contract, you honor the contract. Okay, Tom. Yes, thank you very much, Tom. Appreciate it. Okay, Karen was actually driving Uber. Okay, and this is the person, $150 a month. Can you hire an attorney at the recon stage? Yes. And you wouldn't think $150 a month is not going to create problems for somebody, would you think?
I wouldn't think so.
No, I don't think so either. Okay. Okay. Have you heard now they'll be hiring other experienced people throughout various cities to speed up the case? I haven't heard. Have you heard that? I haven't heard that at all.
No.
No.
I mean, they've cut so many people.
Yeah, they're cutting people. I mean, the new commissioner is very much about mechanizing it and AI and electronic stuff. I don't think that I think they see humans as sort of they want to move away from human beings. They want to do, more electronic stuff. They don't want to hire more people. They see that as a negative. So yeah, they're not going to hire more people, I don't think. For those who work, does it concern the number of hours they allow people to work 20? I think it's really more about I think the hours are important because, SGA, or substantial gainful activity, one way to determine is based on the earnings. And again, as Elyse said, $1,690 a month gross earnings is the SGA cap. But if you're volunteering someplace and you're doing it 6 hours a day, and it's a volunteer work that if you were getting paid would pay you more than $1,620, that can be SGA. So 20 hours, yeah, it's a good rule of thumb. I mean, it's not written in stone, but yeah, I think assuming that you're getting paid $10 or $15 an hour, 20 hours is not going to take you over SGA. So I'd say that's probably not a bad place to start, but you got to run the numbers, do the calculations. All right. Okay. Mr. Pet Momo,
Pet mom of 4.
Pet mom of, oh, okay. Thank you very much. Pet mom of 4. See, I'm looking at this, shows how your mind works. I mean, you're seeing it right away. I'm like, Mr. Pet mama 4. I don't know what I'm doing here. Okay, what's late here? I'm getting old. So anyway, why don't you take this one? My husband's considering applying. He has depression, anxiety, bipolar, has 2 heart attacks, and is diabetic. He has high blood pressure and high cholesterol. And let's see, it's all, but wait a minute. Wait, there's more. It is controlled with medication. He just turned 61. So are all these conditions controlled by medication? How would you analyze that?
When did he have his heart attacks?
Yeah.
I mean, if this was something that happened, 20 years ago, and it really is not affecting him, then it really doesn't matter. Again, the high blood pressure, the high cholesterol, is he passing out? I mean, there's just so many things. It's really hard to tell,
Mm-hmm.
What the conditions are. I mean, if they're controlled by medication, it's all controlled with medication. So he may not really have any physical limitations because of that.
Yeah, really. What are the functional impairments, right?
Right. And then again, with the depression, anxiety, and bipolar,
Yeah.
does he have problems concentrating? Does he have problems focusing? Does he have problems getting along with people? I mean, you really need to know what limitations he has.
And I think also that, the heart attacks could limit him exertionally. If you've had 2 heart attacks, maybe you have some permanent damage to your heart. Maybe that limits you to a light RFC, and which means that you're not going to be able to lift more than 20 pounds or stand 6 hours, or maybe less than that. And then when you add all these non-exertional problems, and also medication side effects, that can be another thing that will reduce your functional capacity so you meet the grid rule. I mean, you got a 61-year-old.
I was just going to say he's 61.
Yeah, all these problems. I can't believe that it's 100%. I mean, and that's the other thing. Medication, when you say it's controlled, is it 100% controlled, or is it, just making him a little bit more functional? I'm not convinced that a person 61 with all these problems, 2 heart attacks, is going to have every condition controlled with medication. I don't think the medications are that good. So I think you have to really look at what limitations he does have despite the medications, the effect of medication side effects, the effect of that heart attack, and really look closely at the grid rules, because I think that may be a good angle for you. And again, does he have a good chance? It just depends on what the medical says. I think we can't really say because we haven't seen the medical. Steve Whitaker went to the office to fix an issue, told him I was applying and have an attorney. They locked in my report date, scheduled me a phone call, said I had to do it. I guess they considered your appointment to be like a form of an application. They're treating it like it's an application. And so you don't have to take the phone call, but if you're going to be applying anyway, you've already got the process started. I think that's what's going on here. So, no, you're not legally required to follow through, but they'll dismiss the case if you don't cooperate. So, if your attorney's already filed, you don't want a double application going on there. I would probably ask your attorney to see what they can find out, he or she can find out, because it sounds like either that they're taking a new application when you've already got one pending, which you don't want, or they treated your visit as if an application and you were thinking about it but hadn't yet pulled the trigger. Now the trigger's been pulled for you. So I think that you just have to decide what you want to do. But I think if you've already got an application going, you don't want another one. If you haven't, let this be your application, because I've had experience where somebody, like I have one right now, somebody filed his application. He got really confused by everything. It was frustrating. He's like, I want you to take it over. And the problem is I can't, even though I've got his reentry code, it's hard to get back into his account because of all the security questions. They're probably going to make us do it on paper. So you kind of want to avoid that, is my take. Okay. All right. At what point in the process? Brian asked about the medical records. I think really, as Elyse said, really any time. And then Christina says, that I reminded her of someone that only went to sixth grade, only finished the sixth grade. The person's done heavy work. Well, that's, you look at the grid rules, and that's what the grid rules were designed for, right? For the person who's done heavy labor without education that would allow that person to move into more skilled work that's less physically demanding. That's exactly what the grid rules are. No GED, she says. That's exactly what the grid rules were designed to. Okay, I hope you're talking about us. Highly recommended. All right, let's see here. And this is just somebody who's responding to 4 o'clock about the hours. Okay. Okay, there's some discussion about the trust funds. I don't think any of us know what's going to happen with that. Okay, good question here. Aurelius Saul. Does having a master's or PhD disqualify you? What's your take?
They're going to look at, well, you have skilled work. And so can you do other work? And so it wouldn't disqualify you, but, you may not. I actually have to look at, I don't have the grid rule in front of me, but
I
there's.
think it says either high school grad or more. I don't think it says, I personally think, I've had people with master's degree, with PhD. Typically they are going to be working in a very specialized area. And if anything, it may limit their past work to that particular industry and what they did. And they may not be able to easily transfer to something else. And realize having a, PhD or master's doesn't mean they did skilled work. They could have, probably did, but doesn't mean it. And certainly doesn't make, think about it. If you have a PhD in philosophy, okay, is that going to really help you in the job market? You're smiling. I hope you don't have a PhD in philosophy.
No, I don't.
But I'm not making fun of it. But yeah, I think that the way the grid rules are written, it's high school or more. So I think that, a judge might look at you and say, well, you probably are educated. You may have intellectual capacity that would give you maybe more flexibility. But, that's a long way from saying you could make an easily adjust from being, a philosophy teacher someplace to, being a, I don't know, pick a job, a semi-skilled type of job, warehouse supervisor. The two are completely different. So I don't necessarily think it's a big issue. I think the 40 years old is the bigger problem, in my opinion. Right. Wouldn't you agree? I think that being Absolutely. 40 is hard. I've had cases with people that are, doctorates and so forth. And honestly, having met a number of people and knowing a lot of people with high advanced degrees, sometimes they're book smart but have no common sense at all. So you can't assume. I know lawyers who have JDs and they're idiots. They don't know anything. So you can't assume anything.
I know the same people.
Yeah. Well, and they have egos too. That's the worst part. But that's a story for a different day. Okay. Viewing on a laptop. Yeah, okay, that's good. Okay, so we're good on that. Okay, so we got about 10 more minutes or so. And I had Kathy Clayton had a CE on 12/30/25. How long does it take? Okay, so I think what she's asking is, had a CE at the end of December. What does that mean in terms of the time frame for getting a decision? My thought is there's no correlation at all. It depends on when the file gets completed. Do you have a different take?
Depends on when the file is completed. I agree with you.
I think so too. I think so. I've never had a woman agree with me so much. You're saying I agree with you. I need to introduce you to my wife because nobody ever. I've never had a woman agree with me this much. It's okay. All right. It's certainly not my wife, but that's a good story for a different day. All right. Kayla. I'm just going to leave it at Kayla. Applied for disability around the fall of 2024. Still been approved. How long does it take? Applied for PTSD and have mild sleep apnea. I think that it depends on where you live. You're now at over a year. When I tell people when they're at a year like that, they should reach out to their U.S. senators. They should reach out to the elected representatives to get a congressional inquiry. Agree?
It's happened at times
Yep.
with it, the senators do write a letter and they're pushed ahead.
Yep. They get to the front of the line, just like 100% VA disabled get to the front of the line as well. On a journey. Okay, we're going to zoom through some of these because we don't have a lot of time left. My friend had the ALJ ask for more medical evidence to push the next hearing date a year out. Okay, so the ALJ obviously did a hearing, or your friend had a hearing. The ALJ basically said, we need more evidence, and then scheduled another hearing. It's going to be a year out. I don't know that the ALJs, I mean, normally they put you back on the hearing docket, and whenever that happens, it happens. But their backlog could be. Okay, and here's somebody suggesting Ed Weir has he's got a very robust YouTube channel. He calls himself, he was former head of a Social Security office, and I've talked to him before. Nice guy. And he, she's saying that Zippy says that Ed believes there may be a cut in benefits and so forth. Again, that's Ed's opinion. I mean, he's been an insider, but he's away from the agency for a while. We don't know. Nobody really knows. All right. Can the grid rule used for migraine be used for a diagnosis of migraine? I don't think so. It's non-exertional. I mean, it's pain, but unless it limits you physically from lifting, standing, climbing, things like that, it's a non-exertional impairment. You still have to argue functional capacity, I think. So I don't think so. Okay. All your records from high school. And again, those may not be all that relevant if you've worked. In other words, people will say to me, I've got records going back 30 years, but if you stopped working 3 years ago, then records that showed a medical problem, but then you worked despite that problem for X, Y, and Z number of years, how relevant is that other than to show there's a long history of this condition? So I don't know that records from high school, with the one exception of psychological records, that may show, long-term psychological issues. And actually, let me give you another point. And I know we're getting close on time. I'm just going to raise this one point, and I'll probably do a video on this because it actually happened to me recently. Client testified, judge was asking, tell me about your migraines. Oh, I've had those since I was a child. Tell me about your back pain. Oh, I've had my back pain since I was a teenager. What's the problem with that? The problem is you worked. Okay, you had the migraines since you were a child, but you were able to work for 30 years. And then now 3 years ago, you stopped working. You got to explain that those migraines got worse in the last 2 or 3 years. You got to explain your back pain got worse. I mean, if you had a chronic condition that you're able to work through it, the logical question is, could you work through it now? And, maybe you've gotten older, maybe the condition's gotten worse, but you have to make that connection. Don't assume the judge will make it. So, if you've got a long-term kind of problem, that doesn't necessarily, that's not going to always help you, because again, you've got to show that that problem has gotten worse recently since your onset date, and that, or that other problems have come about that made that problem that was once manageable not manageable. But you got to connect the dots, I think. So, Alicia, let's see. Owed more money. Okay. I know we had emailed a little bit. They're saying that you owe more money, or that they owe you more money. I think that they say you owe more money. Yeah, there's a problem there that they're sending you money, then they're saying, and I know it has to do with some work that you're doing. I'll email you on that. I have some thoughts about that. I don't want to discuss it in a public forum, but I think I know what the issue might be, and I'll send you an email or reach out to me in the next couple of days, and we'll correspond about that. Okay, we got a time for a couple more, then it will be done. Vince is my client in Michigan. You got a warming trend, okay, but it's going to be a deep freeze. Yeah, we had really cold weather a couple weeks ago. They're telling us it's supposed to be really cold this weekend. Now it's just going to be rainy. And it's going to rain out my tennis match, which is not going to be good because I'm the captain. I got to reschedule it all. but you've got negative 18 with a windshield of negative 32. Vince, my friend, you can have it. Elyse, you're in New York, you can have it. I don't want that stuff.
He's in New York?
No, Vince is in Michigan.
Oh, okay.
He gets all that lake effect stuff, and you're in New York, so I know you get the cold weather too. I'm a Southern boy. I like it nice and warm here. We don't like that cold weather nonsense. Okay. Okay. Let's kind of end on this one. I know we have a couple more, but I'm going to end on this one. Federal quality review. Tell me about that. What do you know about quality review and decisions at state agency or at hearing? How does that? Well, people get real frustrated.
From the hearing perspective.
Yep.
Hearing office perspective, we did not like quality review.
Okay. Why?
They had a list of something like 96 questions, and they would just check the box to make sure everything was met. And they would find faults with things that, just, we just disagreed with quality review.
So tell us what it is. What is quality review?
So they pull decisions. They randomly pull decisions, and they have a checklist, and they go through and make sure that everyone is doing their job according to this checklist.
Is it favorable and unfavorable decisions, or just favorable?
They just pull it. It's just random.
Okay. Have you ever seen decisions reversed?
I've seen quality reviews say it shouldn't be, this finding. And I once had a case where quality review changed the RFC, and they sent it back to me to write it. And I went to the judge and said, this doesn't make sense.
Mm-hmm.
And he was really angry. He's like, I didn't make that finding. This is my finding, the way it is. I don't care what quality review said. This is my finding.
Yeah.
And I want it done this way, which is the way I had done it.
Okay. And what happened?
He was the judge. It went out, he signed it, and it went out the way he wanted it.
Okay. Are the judges pretty independent as far as what they do? Okay. Do they get pressure from Congress or the agency to do this, that, or the other?
They get pressure from the regional offices,
mm-hmm.
but again, they're independent.
Okay.
And they are the ones who are making the findings. And, if the office doesn't like it, they can then bring it to quality review, or, let it stand, and then it'll be reversed if it's not.
And the pressure you're talking about from the regional office about approving too many cases?
Yes, that's happened before.
Okay.
And they're not approving enough, or they're not, they're just slower, and they're not getting as many cases out as they should.
Okay. All right. I'll end with this final. I have two more questions for you, then we'll end. Number one is, one of the things that always drives me crazy about Social Security disability. You look at the stats for a hearing office. You see Judge A, 72%. You see Judge B, 28%. You see Judge C, 17%. How is that fair? I mean, is that something that Social Security aware of the wide variety of approval rates? Does that matter to them at all?
I don't know. I agree with you. I think it's just terrible. You had in my hearing office, the longer term judges retired with me, and they were the ones who did mostly, who granted mostly favorable, because they know the law, and they know, what this person really can't work. And so the ones I've decided that a lot of the ones with high approval ratings are the ones who have left. And unfortunately, a lot of the newer ones who I guess feel the pressure to deny, they're the ones who are now in the hearing offices.
Great. I don't want to hear that.
Unfortunately.
Yeah. Okay. And I got one more question before the last one. There's been a lot of talk about vocational witness questioning, and that ruling that talks about the process. Do judges get upset when you aggressively question a VE, vocational expert?
This rule came after I left.
Okay.
Considered.
Okay. So you wouldn't. Okay. just curious as to what you have an opinion about that. All right, tell the folks how, if they want to reach out to you, how they would do it.
So my name is Elyse Entin, ELYSE ENTIN. I have the law office of ElyseEntin.com, and I also have disabilityattorneynewyork.com, and you can look at it online. That's my Facebook. I'm sorry, my website, and I'm located in New York, but Social Security is
Virtual
federal,
now.
so I can handle cases all over.
Yep. It's virtual now. That's one thing that's really nice about it is a couple of things I give them. Look, we criticize Social Security a lot because they're, a big, inefficient, sometimes very unfair agency, but there are a couple of things they've done well. They went paperless, which years ago, probably, certainly before you went to private practice, we would do physical folders. So that's done, which is great. So you can access it electronically. So I can sit in my pajamas and review my cases, which is really nice. Although not seeing me in my pajamas is not nice, but to be able to review the cases is nice. And then the second thing is the hearings are now virtual. So I can try a case, out of New York in the morning, Houston in the afternoon, and California in the evening. And so it just makes it easier for attorneys to, make their services available. It gives you, the claimants, more choices. And I think those are really positive things. You don't ever see live hearings coming back as the standard, do you?
No one wants to do it.
Yeah, I don't think so either. Before COVID, it was all in person, and that was just a pain. I mean, it was just a real pain, but this is much, much better. So, okay. Well, we've been going at this for 2 hours and 6 minutes and 39 seconds. So we will close it out now. I very much appreciate you spending your Wednesday evening with me and our audience. I'm sure they do as well. We'll do it again at some point. And thank you very much. So everybody have a really, really great weekend. Stay warm wherever you are at. If you have any questions, of course, bring them next week. I'll be here, and we will see everybody soon. Thanks a lot.
Thank you very much.